premises, establishment of zones, offences, notices and definitions. Within the group, Amendment 2 is mutually exclusive with Amendment 1 and Amendment 9 is mutually exclusive with Amendment 7. I would remind members intending to speak that during the debate on single group of amendments, they should address all of the amendments on which they wish to comment. Once the debate is completed, any further amendments in the group will be moved formally as we go through the bill, and the question on each will be put without further debate. The questions on stand part will be taken at the appropriate points in the bill, and if that's clear, we will now proceed. We now come to the single group of amendments for debate. With Amendment 1, it will be convenient to debate Amendments 2 to 12 and opposition to clauses 1 to 13. Stand part. I call Mr Jim Allister to address his opposition to Clause 1 and other oppositions to clauses stand part, as well as the other amendments in the group.
Thank you, Mr Deputy Speaker. I've tabled opposition to every clause of this bill because this is a bill which I think carries and contains no merit. It is unnecessary when weighed against the current position of our law. It is a bill which is overwhelmingly vindictive in its approach, and it quite consciously and deliberately expunges and oppresses any legitimate protest whatsoever. It's ironic that there is no choice to protest permitted within this bill. It creates these censorship zones where even the attempt to influence is criminalised. If I go to Clause 6, subsection 2, we see exactly how pervasive this bill is, because it makes it an offence in a zone with the intent or requisite to whether or not it has the effect of influencing a protected person, whether directly or indirectly. So the very issue of seeking to influence someone is now criminalised. And that influencing might be an entirely silent presence. It could be an entirely silent protest. It could be someone simply holding up the words of the 6th commandment, "Thou shalt not kill," in the context that that's what abortion is. So someone who chose not saying a word, not handing out anything, just standing quietly with those words would be criminalised by this legislation. That's how draconian and outrageous it is in its reach. And I do say to this House, though no doubt on past performance, my words will fall on deaf ears, but I do say to this House, stop and think what you're doing. You might be wholly persuaded of the merits and the desires of promoting abortion. That's not the issue. The issue here is, are you wholly persuaded that it is right in 2022 to create a criminal offence out of silent protest seeking to influence someone? Now, there's no point in glossing that over by saying, oh, but this is really to deal with harassment, which isn't even defined in the bill, or with abuse or violence, all of which are covered in the current law. No point in saying, oh, it's really to do with that. If it were really to do with that, then 6.2a would not be in the bill. But 6.2a makes it a criminal offence to seek to influence and creates these censorship zones at the behest of the operators. So I do say it is one of the most incredible things that any bill would so lose sight of fundamentals that it would put this draconian measure upon us. You know, freedom of expression, we were hearing about it in the debate before this by some of the very people who I suspect will vote for this bill today, lauding freedom of expression. But freedom of expression provides equally for saying the unpalatable as it does for saying the palatable. There's no sifting in freedom of expression that you must only say that which is palatable. Freedom of expression also entails saying the unpalatable. But freedom of expression under Clause 6 in this bill is totally expunged. And therein is something that is quite unpalatable in itself. Even silent prayer is now a criminal offence. Someone could go to one of these facilities, stand within the zone, silently pray, indicating their position on these matters, and they could be capable of being criminalised. That's how dastardly the extent of this bill is. And of course, it doesn't exist anywhere else. The Home Office decided against it. Scotland decided against it within this United Kingdom. But here, we want to put it upon individuals and society in general. I said there's no definition of harassment. I made this point at the second stage. I thought the sponsor might at least have taken that under her notice, because harassment in law is already defined. It is defined as causing alarm, etc., which of course is also alarm or distress is the legal definition of harassment. But this bill, in its tautology, says causing harassment, alarm or distress. So what's the harassment here? It's obviously not alarm or distress. It's obviously not harassment as defined in the law. So one would have expected to see in this bill a definition of whatever harassment it is that this bill refers to. But that's maybe just a side issue. But where this bill gets really oversteps the mark is in its audacious move to create self-certification of zones, at least under the existing clauses. Under Clause 3, it was the Department, Clauses 3, 4 and 5. Following a request from the operator of the premises, the Department makes a determination that the premises are be treated as a protected premises. And it may only make that determination if it, the Department, is satisfied it's reasonable to do so. Along comes Amendments 3 and 4, and they remove. Amendment 3 removes that role for the Department and that obligation to ensure that it's reasonable to do so, and simply leaves a situation where a zone arises when it's self-certified by the operator. So they get to write their own laws, their own rules. They don't have to go through any filter of any department. All the department comes, its sole role is to hold a register of these places. But under Amendments 3 and 4, we have this absurd position whereby a zone is established on self-certification. That's the import of Amendment 4. If the operator of any protected premises is of the opinion that the public area mentioned in subsection 2b is not adequate to afford the safe access, etc., they can even extend it up to 150 metres. So they make it in the first, it's made in the first place, and then they can extend it on their own whim, self-certify it, with no consent or needs for the department. And the only duty of the department is in 5A4, the department must include an entry relating to the premises in the list maintained under Section 8A. So it really is unbelievably audacious that this bill would bestow upon the operators the self-certification rights to create and to extend these zones within which to silently protest is a crime, within which to silently stand, as I've said, with a copy of the 6th commandment, thou shalt not kill, is a crime. Yes?
I'm not sure how many of the sessions you listened in on, but when we heard from the chief executives of the trusts, we heard about a woman who was coming to Northern Ireland to seek refuge here from Eritrea, and en route she was sexually assaulted. And when she arrived here to have her healthcare needs met, she was harassed at the entrance. And so, while I understand and I support the right to protest, I also think the needs of women in her particular circumstances and similar should have primacy in terms of their needs. Would you agree?
The member says she supports the right to protest, yet I guarantee today she will vote to expunge all right to protest. So there's not much point in her coming to this House and saying she supports the right to protest when she's going to vote to take out Clause 9.
People can protest, but outside the safe access zones. That is what I will be supporting today.
So you are going to create zones which are allowed to contain one world view, that of the pro-abortion view, and within that, even though it's a public place, it is outside the public right to express a view contrary to the pro-abortion view within that zone. That's how audacious this is. And if the member is saying that this is about harassment, then you don't need influence. You don't need to criminalise influence, because that is already covered in 6(2)(c). So, the point here is you have to look at a law. What is the breadth of it? And the breadth of this law is that it can criminalise mere silent protest if it is thought capable of influencing someone. I give an example in the second stage debate. Take the 14-year-old girl who gets pregnant. She's determined to have an abortion. Her mother doesn't wish her to. She wants her to deal with this in other ways. She tries to give motherly advice. The young girl says, no, I'm going to do it. She heads down to the abortion clinic. The mother goes with her, pleading with her not to do it. Once the mother steps within this zone, she's the criminal, because she's trying to influence the minor not to proceed. She becomes the criminal. That's how absurd this is. Yes?
Thank the member. But if the member looks under clause 4b, accompanying person described in paragraph A, at the invitation of that person, will also be a protected person, therefore the mother that you're speaking of.
At the invitation of that person. If the child says, I don't want you to come with me, I'm going to do this on my own, I'm getting an abortion, I don't care what you say. And the mother says, I'm your mother, I love you, I care for you, I want to persuade you not to do this. Once that mother steps over that line into this zone, that mother is a criminal, according to this law. And that is how absurd this legislation would be. We're going to criminalise mothers showing motherly concern for their daughters because they're not allowed within that zone to seek to influence the child. Now, really, is that what this House wants to do? That is beyond comprehension, I would suggest. Returning to this tyranny of self-certification, there's no oversight, there's no appeal, there's no proportionality. It's just on the whim of the operator. We want to extend it to 150 metres. That's all right then, you do it. No oversight, no asking the department, nothing whatsoever. And when you look at clause 8.2, it gives, as the bill presently stands, this is the notification of the zoning. Within 8 weeks of receiving this notification, the department must designate an area as a safe access zone. That's gone under these amendments. Amendment 8, all you do is you make the department the depository for a registry. They keep a register of where these profit-making organisations, some of them, self-certify and decree. The matter is beyond comprehension that any house would want to hand to profit-making organisations such as this that control over the public streets. Because that's what they're doing. This is public property. And they are going to self-certify who can and cannot go. And in taking out clause 8, of course, you take out the 8.3, the power to consult by the department. You take out the power in 8.4 to vary the determination. You take out the power in 8.5 to revoke. So all of that is to go under this. And then there's an amendment to take out clause 9. If there was any saving grace in this bill, it was the indication that in the exercise of its functions, the department must have regard to 3 things: safety and dignity of the protected person, the right to respect for private and family life in Article 8, the right to manifest religious belief, and the rights to freedom of assembly and expression set out in Articles 9, 10 and 11. What does the sponsor do? She comes along with an amendment to expunge clause 9. So the very essence of any regard to freedom of expression that was in the bill is now, by this sponsor, designed to be removed. So what you're left with is no-go zones for the department. These are zones of censorship, self-certified by the organisers, where it is a criminal offence to dare to breathe anything that might be interpreted as influence, and you just abandoned the zones to the control of the abortion clinics. That is what this legislation is now, through these amendments, coming to. So any semblance... Yes?
Thank you for letting me in. You keep using the word influence. Do you not think that by the time the woman or the girl has arrived for her healthcare services, that she will have already gone through an agonising process? So by this stage, she will have made up her mind. So I don't think it should be on anybody else to try and influence her at that point.
Well, the member might be so in favour of destruction of the unborn that she thinks that no one should have the right to try and influence someone not to destroy the unborn. But I disagree. It is one of the most fateful steps that any mother or anyone else can take to destroy the unborn. And surely we live in a society where legitimate influence should still be recognised and honoured, instead of expunged, as this bill, instead of criminalised, as this bill will do. So I really do say to the member that we are headed down a road which is quite shocking. And all of this with no regard to the existing law. Article 9 of the Public Order Act, Public Order of 1987 makes it an offence to use written material that is threatening, abusive or insulting. What's wrong with that? But patently it's not enough. Harassment is provided for in the Protection from Harassment Order 1997. You can even get a restraining order under that order. Disorderly behaviour is provided for in the 1987 order. Article 4 allows conditions in public assemblies. So if you have a situation where there's a routine of regular protests, they can be regulated by Article 4. But instead, along comes this bill and this sponsor to say, I want to even amend my bill to the point where anyone who steps foot within 150 metres of one of these abortion clinics will be criminalised if they dare to try and influence anyone. And some of these may well be in public bodies, public buildings that have other purposes. And the whole zone applies in respect of all of that building. You know, such unbelievable presumption on their part. The member referred to taking evidence. Yes, I had a look at the report. I was struck by how diffident the committee was in hearing anything but one side of the story. 6,459 submissions, written submissions, and only 13 of them supporting this bill. A slate of witnesses, but a refusal to hear from those opposed. This committee covered itself in, well, certainly didn't cover itself in glory in dealing with this matter. It covered itself in bias by virtue of the fact that the people it wouldn't hear from. And no doubt that same bias will be here today, refusing to hear. Yes?
It's just on that issue. I think it's important to note, in a defence to the committee, that the decision was taken that those people that were offering their view on abortion, not on the issue of access to the clinics, and that the decision was taken to listen to the people who had a view on that issue, because to have taken all of the issues in, we would have been reopening debates to which this particular legislation didn't cover, and that actually that's quite diligent and not biased, as you would put that through.
Was there not a group of laymen and ministers who asked to be heard and were politely, if it was politely, told to go away? We don't want to hear from you. Sure.
Those views were taken into account as part of the written submissions.
Yes. So you tell us written submission views were taken into account, and 6,459 were all against the bill, all but 13. And their views were taken into account, and here we are, still with the bill, with the chairman and others about to even make it worse by supporting these amendments. Who does the chairman think he's kidding when he says those views were taken into account? Over 6,000 objections to this bill. There's no evidence in this report that they were taken into account other than counted. They certainly didn't count when it came to the argument. And this was a committee which consciously and deliberately was deaf to views other than those which fitted the bill. And that is exactly how we got here. So it is a bill which is unworthy, in my respectful submission, of any support in this House. It drives a coach and horses through basic, elementary, lawful expectations as to freedom of expression. It outlaws that, and it elevates to a point that's unbelievable the rights of these abortion clinics to self-certify for themselves the zones, and removes the very department from any oversight of that. It is a quite appalling and unnecessary piece of legislation, because as I've read to this House, there are multiple limbs of legislation which cover unruly, inappropriate behaviour outside in any public place, but not enough for this sponsor and this bill. They want exclusivity to only have their view capable of expression, and the right to even silent protest expunged. That is something I will not and cannot endorse, and therefore will oppose today.
Éireann Chaithilach an Coiste Sláinte, Colm Gildinú an Cainse. I call the Chair of the Health Committee, Colm Gildinú.
Speaker, during the debate on this group of amendments, I will give a brief overview of the committee's scrutiny of this bill and will make some further comments on the committee's view on the bill's sponsors' proposed amendments. The committee has not considered the amendments in the name of Mr Allister and Ms Bradshaw, and therefore there is no committee view on those amendments. So, the bill seeks to allow for the establishment of safe access zones outside premises which provide lawful abortions or related information, advice or counselling. The bill also creates offences which apply to safe access zones and allows the police to enforce these offences. The proposer of the bill, Ms Bailey, briefed the committee on the 7th of October 2021 on the principles of the bill. The bill passed second stage on 12th of October and was referred to the Committee for Health for scrutiny at committee stage. The committee issued a call for evidence, and there was a substantial response to the call for evidence, with the committee receiving a total of 6,459 written submissions. A total of 47 written submissions were received from organisations, with the rest coming from individuals. At its meeting on the 2nd of December 2021, committee members agreed to take oral evidence from a number of statutory organisations. Evidence sessions were held with the Department of Health, all 5 of the Health and Social Care Trusts, the PSNI and the Human Rights Commission. The committee also took evidence from the sponsor of the bill on 3 occasions. We received correspondence from Abolish Abortion on the 19th of January, asking the committee to reopen its evidence gathering to allow ministers and pastors to give evidence on the bill. The committee considered this request and outlined that there was a significant response to the bill from organisations, including responses from statutory bodies, staff representative bodies, professional bodies, pro-life organisations and pro-choice organisations. Members felt that the views of organisations and individuals were clear from their written submissions, and the members have used those written submissions to inform their views on the bill and therefore would not be reopening oral evidence sessions on the bill. The committee did receive a wide range of views, with the vast majority of individual responses not in favour of the bill. And I am certain that Mr Allister will understand that committees generally do not take evidence from individuals. It is also the case, and maybe Mr Allister could advise us, would he suggest we should have taken evidence from all 6,000 or just from the members whose view you support? So, I will.
We just finished debating the defamation bill. I sat on that committee. We heard from several individuals. So it's not alien. It's not alien to hear from individuals. But here you had 6,000 people expressing a view and you didn't want to hear from one of them.
Their view was clear and was presented to us, and I'm certain you're not suggesting we should have heard from them all, and therefore how would we pick? Well, which one should we have heard from?
Excuse me, gentlemen, it's not a dialogue, just if we could confine our remarks to the bill and through the Chair, please.
Approximately 27 outlined their general support for the bill and 18 outlined their opposition. I would like to thank all of those individuals and organisations. Pardon?
How many did you hear from?
I'm going to outline who all we heard from in the course of my remarks. I would like to thank all of those individuals and organisations for taking the time to submit written evidence, and would like to thank all of those who attended committee meetings and gave oral evidence. Yep, go ahead.
And I thank the member for giving way. The member will know that myself and Pam Cameron did ask in the Health Committee for the evidence to be reopened, but the Chair will also agree some members were also allowed to give their views when it came to the severe fetal abnormalities bill as well. So could the Chair just maybe speak into that as to how many people were able to give their views during that evidence session?
Well, that was clearly as a result of a request from the sponsor of that bill that a particular individual who has taken a court case would be facilitated, and we felt that was appropriate and actually a compassionate thing to do. That doesn't mean that you can create then a precedent that you hear from 6,000 individuals whose evidence has made it very clear what their view is. So you're still left with the issue of how you would fairly address individual responses of 6,000 people. Go ahead.
Grateful to the member for giving way. I accept entirely the point that you can't ask all 6,000 people come in front of the committee. But could I ask, in relation to the clergy and lay people who are coming, who will represent thousands of people in Northern Ireland, why did the committee think it was not a good idea to hear from them?
The committee discussed that matter, and we agreed as a committee our approach to it, and we moved forward, and that is how. And those are all contained within the reports. The Hansards will be there. I would advise any of you who wish to revisit that issue to go and have a look at it. Okay, and move on. Last chance for you. I would like to take the time to thank all the individuals and organisations for taking the time to submit written evidence, and would like to thank all of those who attended committee meetings and gave oral evidence. The committee was briefed by the bill sponsor again yesterday on the amendments that she is bringing forward. Clare outlined that she had worked with the Office of Legislative Counsel and the Department of Health to draft these amendments. While acknowledging that these amendments were brought late, the committee welcomes this joined-up approach and cooperative working by the sponsor and the department. And I do think that is a good example of a department working with the sponsor of a private member's bill in order to ensure it's as robust as can be. I would outline that the committee's clause-by-clause consideration of the bill was based on previously tabled amendments by the bill sponsor, and therefore does not take into account some of the amendments we have before us today. I would also note that the Deputy Chair, Pam Cameron, and Deborah Erskine did not take part in the formal clause-by-clause. So in relation to safe access zones, the committee heard evidence on the reasons why safe access zones are required. The Belfast Trust advised that since the beginning of 2021, despite lockdown and COVID-19 restrictions, there have been weekly protests from various anti-abortion groups outside their clinics here, including its College Street premises. The Belfast Trust advised the committee that protests cause considerable distress and anxiety to patients and staff. The Northern Trust also advised that it had to move the location of its clinic on 2 occasions, as there were concerns about the ongoing impact of personal and abusive protests on service users, and that there were concerns for patient and staff confidentiality. The PSNI advised in correspondence that in the 12-month period from January 2021 to January 2022, police were requested to attend 55 incidents related to this issue. Many of the organisations described the detrimental impact of the actions and behaviours of protesters on those accessing services, and highlighted the impact on particularly vulnerable groups such as minors and those attending services as a result of sexual assault. Some of the organisations pointed out that the actions and behaviours of protesters can cause distress to those who have suffered pregnancy loss and those who live with fertility issues. I would also outline that many of the organisations that opposed the bill also condemned situations in which women and staff were harassed or subjected to behaviours which would cause stress. They also stated that behaviours described were not the norm, and that protests that take place are often peaceful. However, I would outline that all members of the committee agreed that there is no place in our society for the harassment, abuse, intimidation of women and girls accessing health services, and that patients, staff and visitors should be able to access health premises free from harassment, abuse and intimidation. And I sincerely hope everyone in this chamber agrees with that. In terms of human rights, the committee sought the views of Human Rights Commission on the balancing of competing human rights, and in particular the right to privacy against the rights to expression, association and religion. The Human Rights Commission advised at the committee that the bill engages Article 8, 9, 10 and 11 of the ECHR that require consideration. The Commission advised that none of these rights are absolute rights and can be interfered with and limited under certain circumstances. The Commission advised us that the European Court of Human Rights, in considering restrictions or limitations, has held that the restriction must be prescribed by law, have a legitimate aim under the relevant article, and must be necessary in a democratic society. To demonstrate that a restriction is necessary in a democratic society, it must also be proportionate. In light of this, the committee advises that in the case of safe access zones, there are legitimate aims such as the protection of health. Go ahead.
Did the Human Rights Commission also tell you about the cases which say that blanket bans are extremely dubious legally, and yet that's exactly what the committee is endorsing here?
The committee's advice is contained within the report and contained within the remarks I am making, as the member will know. In light of this, the Commission advises that in the case of safe access zones, there are legitimate aims such as the protection of health. Where protests are preventing access to necessary health care, causing distress or possibly leading to harassment of patients and staff, protecting their right to physical and psychological integrity under Article 8 of the ECHR is a very important factor. In relation to the amendments in Lascian Corlia, the committee is content to support Amendment 1 in the name of the bill sponsor. This amendment will ensure consistency with the language used in the Abortion NI No. 2 Regs 2020 and seeks to ensure provisions remain workable in practice. Therefore, the committee will be supporting Amendment 1 on the understanding that the committee's amendment to Clause 2 will not be moved as you have outlined. The committee is content to support Amendment 3 in the name of the bill sponsor, which provides greater clarity on how the department will make a determination. The committee also supports Amendment 4, which clarifies the process around when a safe access zone is required to be greater than 100 metres and ensures that it maintains compliance with human rights. The committee supports Amendment 5, which seeks to remove subsection 4 of the clause, that it is a defence for a person to show that they did not know and had no reasonable way of knowing that the protected person was in a safe access zone. The committee supports Amendment 8, which seeks to provide clarity in relation to the role of the department in publishing information on safe access zones. The committee supports Amendment 10, which is needed as a consequence of the bill's sponsor's intention to oppose that Clause 9 stand part. The amendment removes reference to the Convention. The committee supports Amendment 11 as it provides clarity in relation to the specific offence of recording a protected person in a safe zone as provided for in Clause 6(3). The committee supports Amendment 12, which provides clarity on the meaning of premises and what attending premises means within the bill. And I would just outline as well that the vast majority of premises will indeed be trust, and the operators in many cases will be trusts. So I wish to thank the bill sponsor for their engagement with the committee on the bill, and I would like to thank members for the work on this bill over a sustained period of time. I would also like to place on record my thanks to the committee team and the bill clerk for supporting members through scrutiny of the bill. And I also would like to thank the department for working with the sponsor of the bill and the OLC for providing that technical support. So, Lascian Corlia, make a few brief remarks now as Sinn Féin MLA and spokesperson for health. Sinn Féin support the Safe Access Zones Bill, and we thank the sponsor for bringing it to the Chamber. Blocking access to a healthcare clinic is inhibiting a woman's ability to access the healthcare that she might need, and indeed that she is entitled to. Displaying graphic images, handing out leaflets and behaving aggressively towards women seeking treatment is unacceptable and should be unacceptable in any society, in my opinion. It's a violation of rights, and indeed it is indecent and it's disrespectful. Women who are accessing the services they need and workers who provide those services have complained of campaigns of harassment and intimidation that have left them distressed at an already anxious and stressful time. It is unthinkable that any woman in an already distressful and painful circumstances would be faced with such a violation of her humanity. This bill will create buffer zones wherein the rights of all will be respected. The right to privacy for women and girls and workers, the right to access healthcare, and the rights for protesters to protest and air their views, whatever that may be. That form of protest should, however, be respectful, and it should be free from the abuse that has been reported repeatedly to the committee. One's rights should not impair the rights of the other. I won't give way again. By moving protest from the immediate vicinity of the healthcare services, everyone's rights are protected. The protesters have their right to protest, but not to humiliate, not to verbally assault their targets, and women accessing treatment also have their right to privacy and safe, accessible healthcare to be protected. So finally, Lascian Corlia, it is time for the Department of Health to roll out the provision of safe and accessible services that women need and to which they are entitled and should be able to avail of.
I call Pam Cameron.
Thank you, Mr Deputy Speaker, and I welcome the opportunity to speak in this debate. With the exception of Amendment 6 in the name of the member for North Antrim, I will not be supporting any of the amendments moved at consideration stage. I do not support this bill, and my party does not support this bill. I voted against it at second stage and clearly outlined the concerns with this legislation during the Health Committee consideration. We also ensured these concerns were recorded within the Health Committee's report. Mr Speaker, this is not because I believe patients, staff and visitors should be subjected to malicious or abusive behaviour. All patients have the right to access healthcare free from abuse and intimidation. All patients should have access to an environment where they feel safe. The activities against anyone entering or exiting health premises which are clearly harassing and criminal need to be dealt with. However, I am deeply concerned that this legislation and these amendments will not have the desired impact. The criminalisation of direct or indirect influence in Clause 6 of this bill is broad, sweeping and vague. Mr Speaker, under the framework proposed in the bill, there would be no requirement for influence to be undue or unreasonable. Established legal principles have been set aside out of convenience. This is reckless. It is in breach of Article 9, 10, 11 of the European Convention on Human Rights, which establish the right to protest and freedom of religion. Its implications would set a dangerous precedent for restricting other forms of expression in the public sphere. The provisions of the bill would almost certainly be subject to protractable legal challenge, and this would have serious implications for the taxpayer and do little to improve outcomes for those with legitimate grievances. We want all those seeking health services to feel safe, to be free from abuse and intimidation. However, this bill does not distinguish harassing, abusive or criminal behaviour from influencing behaviour. The question we need to ask ourselves is how this Assembly can pass legislation that properly balances competing rights, that is workable, lawful and avoids falsely raising expectations of women and staff. That won't be subject to immediate legal challenge. I am disappointed that neither the Committee nor the Minister of Health have pushed back against the rushed and dysfunctional drafting of this bill. The PSNI have said enforcement would require continuous physical police presence. And where is the Minister of Justice concerned for the potential implications for policing resources? Consultation has been limited and is over 5 years old. Mr Speaker, legitimate concerns of patients and staff should be addressed, but this should be primarily through a comprehensive review of the law on harassment. And sadly, there has been no willingness among the other parties to even consider this as a viable alternative. With these overriding concerns on the record, I want to address the amendments being moved.
No, I take your point, and one of the amendments I was bringing forward was to sort of try and support those people who did want to come and protest, to give them clarity around that. But you talked there around reform of the harassment laws. I don't see any amendments brought forward by your party in relation to this bill that could have addressed the issues that you're raising here today. Why not?
I'll continue after that intervention. Thank you, Mr Speaker. While these overriding concerns on the record are now on the record, I want to address the amendments being moved by the bill sponsor and representatives of the Alliance Party. Amendments 1 and 3 amend clauses 2 and 3 and would grant an unqualified right to premises where abortions take place, as well as those which provide information, advice or counselling to become a protected premises. The only requirement appears to be that they notify the Department. The original stipulation that the Department must be satisfied if it is reasonable to make premises a protected premises under Clause 3 is removed entirely. We cannot support these changes. Automatic entitlement, seemingly with no recourse to the Department to challenge a notification, does not seem responsible or proportionate. In addition, it fails to provide any ability for a consideration on a case-by-case basis of whether the creation of a zone is rights compliant under Articles 9, 10 and 11 of the Convention. Amendments 4 and 12 in the name of the bill sponsor are more significant and deal with the extent of protected premises. Clause 5 is replaced by a stipulation that the safe access zone consists of protected premises themselves and the public areas within 100 metres of the entrance or exit of those premises. This could then be extended by a further 150 metres on request of the operator of the premises. Mr Speaker, under this framework, there seems to be no authority for the Department to ensure that the extent of a zone is commensurate to its location or circumstances. It would impose a blanket approach, regardless of whether the building or facility is situated in a congested high street or city centre or on the health and social care estate. The Department's role would simply be to maintain a register of zones, a gatekeeper, if you will. This in itself, I believe, is deeply problematic. I am open to correction, but I believe the bill's sponsor previously opposed a prescriptive approach to the extent of safe access zones, and I'm not sure what has changed. The reality is that the amendments 4 and 12 are littered with contradictions and confusion. New clause 5 defines a public area as a place to which the public has access without payment as of right. Does that mean hospital car parks that charge entry would be discounted from the calculation of a 100-metre buffer zone? If protesters congregated in that area, would they face prosecution or not? To go one step further, Amendment 12 frames premises to mean the land on which they are situated. This leads us to ask, does a safe access zone start at the entry to hospital grounds or at the front door of the hospital? How can we expect the public to abide by these provisions when the bill is unclear and poorly drafted? Moving on, Amendment 5 removes the defence for protesters to show that they did not know and had no reasonable way of knowing that a protected person was in a safe access zone. And although I can absolutely understand the intentions of the Amendments 7 and 9 in the name of Paula Bradshaw, which require signage marking out safe access zones, I am concerned that this would not result in a safe environment for patients or staff, but rather a conspicuous signposting to the entrance of such services, essentially placing a spotlight on any individual that enters the zone. I am concerned that such a proposal would actually single out patients and staff rather than single out the perpetrators of abuse or harassment, and this could have an effect on increasing conflict and unproductive interactions. Have patients, staff or local businesses been consulted on whether they feel signage would be appropriate or helpful, I would ask? I cannot support these amendments, and my party cannot support these amendments. We feel it would be wrong to dilute what are already very limited protections contained in the bill for protesters, whilst the indiscriminate criminalisation of influence remains at the heart of Clause 6. I am supportive of the Amendment 6 in the name of Jim Allister, and this would ensure that within the context of the original provisions of the bill, within 8 weeks of notification, the Department would designate an area as a safe access zone only after it has given due regard to the right to manifest religious belief and the rights to freedom of assembly and expression set out in Articles 9, 10 and 11 of the Convention, and in particular the right to protest. This obligation to account for such freedoms is glaringly absent under the proposed amendments. Amendment 11 tightens up the parameters of unlawful recording for the purposes of the offence created in Clause 6. However, the reality is that it misses the elephant in the room, namely the ambiguous and open-ended approach to the offence of direct or indirect influence within the same clause of the bill. Mr Speaker, on balance, I feel these amendments would exacerbate concerns regarding the disproportionate impact of this bill on freedom of expression and the right to protest. There is a real risk that the effect of these provisions, particularly if amended, would be to simply displace the bulk of protest activity rather than deal specifically with a minority of individuals engaged in malicious and abusive behaviour. As iterated through our submission to the committee report, this would only serve to present false hope to women who hold legitimate concerns about behaviour directed towards them. And I would urge members to reflect upon the wide range of concerns that have been expressed in relation to the rushed and careless drafting of this bill, and to consider revisiting these matters in a new mandate. Thank you.
Mayor Colin McGrath on Canchai. Call Colin McGrath.
Thank you very much, Mr Deputy Speaker, and I'd like to start right from the outset by saying that this is not a debate on abortion. Nowhere today are we being asked to debate the legislative position of abortion. Nowhere are we being asked to compromise any of the deeply held views and principles that people may have on that. And anyone who tries to paint today as a picture today of being a debate about abortion itself is playing politics with the emotional and psychological well-being of those women who do access these services. But, Mr Deputy Speaker, what we are debating is a series of amendments that have been flagged up as a result of the progression of this bill as it has moved through the Health Committee. They are mostly technical in nature. However, they do tidy up some of the clauses, and I am grateful to the bill sponsor for her work on that to clarify those matters. So, for instance, Amendment 4 seeks to establish the set of parameters of a safe access zone and creates a 100-metre area that would be protected. And I believe that this is helpful as it allows a very defined area of protection for those that are accessing such services. There is also the flexibility, if needed, to increase this distance to 150 metres. Amendment 7, that has been provided by Ms Bradshaw, details the need for signage in certain areas which could identify the people that are in a protected area. There was much conversation about this amendment as it relates to one specific area, which I think needed to be mindful and sensitive, and we would be happy to support. It was particularly detailed to us by the PSNI, who were concerned about their ability to enforce the zones if there wasn't any clearly identified signs that indicate that it was an actual zone. Amendment 8 necessitates the publication of protected premises and safe zones, thereby ensuring the transparency for the public in relation to the protections that are afforded to the premises. I would draw particular attention to Amendment 11, and I would say to the bill sponsor the importance of this one. Regardless of one's view on abortion, it is not acceptable to record sounds or images of a woman who is trying to access these services and then share them on social media. It is not acceptable to record members of staff who are working on the premises, and it is not acceptable to record anybody else that is going into these premises. And as I think I'm nearly sure in saying that the services to which people have some concerns about are not the only services that are available in these buildings. So people could be going to these buildings for other reasons, but we're being subjected to all of the concerns that people had raised, especially the police, who said that they had to be called on quite a number of occasions, and there was always the issue that that could have been for people that were going into the building for entirely different reasons. In conclusion, the bill we are debating does not impede anyone from objecting to abortion services, and therefore the SDLP can support the bill and the amendments provided by the bill sponsor and Ms Bradshaw, and will oppose Amendment 6 from Mr Allister. Thank you.
I call Alan Chambers.
Deputy Speaker, as a member of the Health Committee, I certainly refute any suggestion of a biased approach been taken by myself during the process. Scrutinising this bill was a lengthy, a difficult and indeed at times an upsetting task. Now, my party will be supporting the sponsor's amendments today, which I understand have been worked through between her work and the department. We will not be supporting Amendments 7 and 9, which put a responsibility on the department in relation to signage. We have concerns around those particular amendments. Mr Deputy Speaker, when I made my first contribution in this House some months ago on this bill, I made it clear that it was not to be viewed through the lens of being a pro-life or a pro-choice debate, and that fact remains. The subject of abortion is a matter of conscience for the Ulster Unionist Party Assembly team, but this bill falls outside the scope of where an individual stands on the subject of abortion. At best, it is misleading for some people to try and make this bill into another debate on the emotive subject of abortion. So how my party votes in this bill should not in any shape or form be viewed as representing either my own or any of my colleagues' position on the subject of abortion, either pro-life or pro-choice. However, it still remains a matter of conscience, and that will not change. The purpose of this bill is to provide a degree of protection for any vulnerable woman seeking advice or guidance at an abortion clinic. They may be at the lowest point of their life, unable to share their fears or concerns with even their most trusted friend or a family member. All of the correspondence that I have received about this bill has been from those on the pro-life side who are opposed to it. This fact tells me that in the eyes of many, the topic has been reduced to a pro-life, pro-choice argument that it clearly is not. Many who have contacted me, and I fully respect their motivation, have spoken about those who are following the words of Scripture and taking part in a protest that will lead to them being criminalised. Unfortunately, we have heard during our evidence hearings in the Health Committee, some protesters, maybe only a small number, are not only targeting those women heading into a clinic, but also those who actually work in these clinics, and worse, other members of the public entering such a building in pursuit of other business. And this may include children. The protesters take photographs, they shout loudly. So Amendment 11, I welcome it, addresses the aspect of protesters taking photographs or using videos. I'm sure that we would all acknowledge that this sort of behaviour is unacceptable. The bill allows for a police officer to direct a protester or a suspected protester to leave the safe access zone. They then have the power to remove the person from the zone if they do not leave. At this point, no one has been arrested nor attracted the potential of a criminal record. And we've heard from speakers that there are harassment laws from so many years ago that could deal with this situation. That's fine. But even if you breach those harassment laws, you will attract a criminal record. So it's not the harassment law, or it's not this new law that will make you a criminal. It's your actions that will make you attract a criminal record. The other issue that has arisen in correspondence is the human right to protest and the right to freedom of speech. Those rights also come with responsibility to respect the human rights of others. Those seeking to attend a clinic also have human rights in relation to seeking medical advice, and their rights are equally worthy of protecting. The bill has sought to find a balance between all these competing rights. The right to protest directly outside a clinic will simply be displaced to a point 100 yards away from the clinic. It will not stop you protesting. The right of an individual to enter a clinic for whatever reason will also be protected by the bill. It will prevent any individual being intimidated or subjected to behaviour that would cause them to feel either threatened or fearful. I believe the bill, as amended, respects everyone's rights, be that to either peacefully protest or to enter a building without fear. Thank you, Mr. Deputy Speaker.
I call Paula Bradshaw.
Thank you, Deputy Speaker. I will confirm that I'm not going to be moving Amendment 7 nor Amendment 9, as the Health Minister has written to the committee members, and the bill sponsor outlined what that meant in practice at our special Health Committee meeting yesterday. I do welcome what was in the Minister's letter in his assurance that he will be developing a policy statement setting out how these zones will be implemented. So I will be supporting all the amendments brought forward by the bill sponsor, including those with reference to clauses not standing part, will be opposing all others. Mr Deputy Speaker, Amendments 7 and 9 were essentially the same amendment, and it is worth emphasising why we still need to add clarity to the original bill around this area. This follows on from evidence, as my colleague Colin McGrath just outlined there, given to the committee, particularly around the relative ineffectiveness of the law as it currently stands. It bears repeating and emphasising that safe access zones exist elsewhere. In the words of the Queensland Law Reform Commission, they are to protect safety and well-being and respect privacy and dignity. In an unamended bill, I felt the description of law of the zones themselves was clear. However, and similar to the law already adopted on the Isle of Man in 2019. Usefully, other amendments have now even further strengthened this description, including with reference to the abortion regulations of 2020. What concerned me in our committee deliberations was that the ability to enforce this law when in distress was clearly intentional, was being caused, may have been limited by the bill as it initially stood. To be clear here, we are not talking about reasonable protest, which is legitimate, but about behaviour likely to traumatise or further traumatise. When people are accessing health care... Yes, I will.
Where in the bill, in clause 6, does it say that the criminality is limited to circumstances where the behaviour is likely to traumatise? It says no such thing. It is all-embracing of anything likely to have an effect of influencing, no matter how innocuous that might be.
Well, we took plenty. Well, I personally spoke to people who have been traumatised by accessing services, and we heard from the chief executives of the Trust who even talked about how their staff felt traumatised having to run the gauntlet through these protesters. So when people are accessing healthcare, Deputy Speaker, they should not have to run this gauntlet of hate and harm. My intention was and is to ensure this legislation is clear about where this gauntlet is. We need to be in no doubt about the right to protest. Like any other right, however, it is not absolute. It comes with a responsibility, and essentially that responsibility is to behave reasonably. No one can argue that it is reasonable behaviour to target women in a way designed to make them feel angry, uncomfortable, traumatised, scared, intimidated, upset, inadequate or unsettled by subjecting them to a torrent of public abuse as they exercise their right to access health care. Mr Deputy Speaker, the bill empowers the police to enforce safe access zones, and my concern was that the legislation initially did not make it sufficiently clear where these applied. During 2021, the police attended over 50 incidents at premises which would be protected by this legislation going forward. Before that, in the most well-known case, police were deployed at Mary Stopes daily and reported 85 crime occurrences, resulting in just one successful prosecution. And even then, the conviction was overturned precisely because the judge could not be clear that the unpleasant behaviour constituted criminal harassment. This is exactly why this legislation is necessary, but it is also why it is essential to be clear as possible about what precisely that entails. And I would repeat that I welcome the Minister's commitment to looking further at this through a policy framework. So, turning to evidence, Mr Deputy Speaker, evidence was brought to the committee emphasising that there would be a potential defence under the legislation as it stands, that those engaging in abuse did not know that they had approached a protected person. This was raised on the definition of protected person, but in my view it also emphasises the need to be clear about where the offence applies. The reason for this is not just about legal defence in the event that someone is charged with an offence. It has to do with knowing when the police should be called, and indeed about providing clarity to prevent offences from occurring in the first place. In other words, what I want to ensure is that there is no uncertainty, and that where there is space for reasonable protest, that is defined as well. This is to reduce the potential impact on police resources, and most of all to reduce the likelihood of offences occurring at all. The distinction between reasonable protest and forcing people to run the gauntlet of hate to access health care will need to be very carefully defined going forward and established, not just in law but also on the ground. So in conclusion, I hope that the bill, as now strengthened by these amendments, can now proceed with this uncertainty reduced. I support the amendments of the bill sponsor, and just would like to thank her and the committee staff for their work during the consideration stage. Thank you.
Agus na siarm sir Emma Sheeran hon cain se call Emma Sheeran.
Gora Margaret, Yas Kincorlia, and I'm speaking, I support the premise of this bill, as I stated during the last consideration stage, and can confirm that Sinn Féin will be supporting most of the amendments and clauses made in the name of the bill sponsor, and voting against the amendment in the name of Jim Allister. I think it's Amendment 6. This bill for us is about righting a wrong. It tackles violence against women and complements a lot of the good work that has been done or is being progressed currently in this Assembly during this mandate. Obviously, we have a high proportion of female ministers at the minute in this mandate, and you can see the impact of that through a lot of the work that we have done to tackle misogyny. And my own party colleague, constituency colleague Michelle O'Neill, when she was the Minister in TEO, led on the strategy to tackle violence against women and girls, and we want to see that progressing. But we've also had bills from across a number of ministers, including the Justice Minister, around tackling stalking, revenge porn, upskirting, down blousing, coercive control, sex trafficking, and issues that have for decades and centuries affected women and have been let progress. And this particular bill works alongside those bills to tackle that and to address misogyny and address the root cause of what is effectively violence against women. These so-called protests are acts of aggression targeted at women, women whose circumstances the aggressors neither know nor understand. That children, people living with disability, staff members are caught in the crossfire, exposed to graphic and harmful imagery without any regard for their personal circumstances is evidence of the intent of the protest organisers. Ireland, as a country, has a shameful, tragic history in terms of how we've treated women and girls in pregnancy. We had Magdalene laundries, mother and baby homes, unmarked mass graves, secrecy and shame, commentary and judgment. And I don't understand why other people's pregnancies are so interesting. I don't understand why another woman's womb is cause for concern to a random stranger who doesn't know anything about her life. But even beyond criminalisation, we've kept a lot of the gender norms and the social stigma that have acted to pressurise and shame women down through the centuries. And as young people, we are all aware of what's expected of us, and we've heard the remarks and the commentary. No babies until you're married. Once you're married, babies right away. If not, why not? Is something wrong? Are you prioritising your career? Are you prioritising some other aspect of your life? And that all carries shame along with it. Yet we don't have funding in this place for the 3 cycles of IVF that we were promised as part of NDNA over 2 years ago, a letdown for those struggling with infertility. And the absence, up until this point, of safe access zones outside clinics is a similar dereliction of duty towards those women and couples who are struggling with infertility. I will.
Agree with me that it's not just those women who are accessing healthcare at that point, but also those women who maybe have experienced miscarriage, who do see the graphic images, see the protest, and it can be re-traumatising for them.
Thank the member for her intervention, and I would agree with that point, and I was just coming on to that around the fact that women who are perhaps undergoing treatment relating to fertility or have suffered an ectopic pregnancy, a miscarriage, the loss of a child, a stillbirth, are going to be traumatised when they're exposed to that imagery, and for anyone to defend that, I think, is cruel and insensitive. It's equally heartless, in my opinion, to impose such pressure on children who may be accessing speech therapy, women who are accessing routine contraception, staff members trying to do a day's work, and perhaps most importantly, the women who are accessing abortion services that they are entitled to in this state under the law. It's been said already by many across this House, this is not about people's views on the topic of abortion. We live in a state that is supposed to deliver healthcare free at the point of delivery without discrimination or fear of favour, and people should be entitled to access health without being traumatised or pressured or catcalled on their way into that particular place. Gormagat Kincollia.
I now call Deborah Erskine.
Thank you, Mr Deputy Speaker. I have thought a lot about this particular bill and indeed the consequences of it, and I welcome the opportunity to outline my viewpoints on it today. And I know this bill will be of interest to many in the public domain. And from the outset, I will make it clear that, as outlined by my colleague Pam Cameron MLA, with the exception of Amendment 6 in the name of the member for North Antrim, I will not be supporting any of the amendments moved at consideration stage. And like the member for North Antrim, I am in agreement in opposition to the clauses of this bill, and I will outline why. Mr Deputy Speaker, I would also like to place on record that my voting on this issue has been consistent and clear. And unfortunately, throughout the course of this bill, passing through the committee stage and at different stages through the House, there have been those in the public domain who have spread false and inaccurate information in relation to my voting record, which has been deeply upsetting and designed to wreck my character and my deeply held views. And I hope that those listening to this speech today will realise the consequences of spreading inaccurate information. Now to the bill in question. I believe that there has been inadequate time to properly consider the bill, and indeed myself and my DUP colleague Pam Cameron MLA made this view clear in the committee. In truth, the fact that we did have the bill sponsor at the committee meeting yesterday to discuss her amendments and yet be in the chamber today debating this legislation speaks to this. For example, we've not been able to properly consider the consequences that it may have around surrounding businesses if a safe access zone were to be implemented, or indeed look at best practice elsewhere. Yes, I'll give way.
Thank you very much for that. And just on that point that you're making, that there hasn't been enough time. I mean, this bill began work in this institution in 2016. We had 3 years with no assembly, and it was finally introduced in September last year. And I note that your party colleague has introduced a bill on the 5th of July, just before recess. This one was introduced just after recess, but your colleague's bill has gone through to further consideration stage, and you're saying that there wasn't enough time for this bill, but there have been for other bills. And the reason that I was at the committee yesterday wasn't because of a timing, it was due to the availability of the OCL and the departmental officials. Thanks.
And I thank the member for her intervention, but a lot has changed since 2016. And I would like to see an updated consultation come forward. Would like to see some updated information that we could properly look at this bill in the round now when we're looking at it in 2022. Yes, we have heard very important evidence which cannot be diminished, and it is particularly distressing to listen to some of the stories that we have heard in the Health Committee. And I do recall evidence in particular of a cancer patient who was attending a clinic not for an abortion but for advice due to the nature of their cancer, and abuse was hurled at them. And I do question care and compassion in relation to those particular cases, because not all cases of protest, however, not all cases of protest create distressing situations such as this. And we have to strike a balance in relation to freedoms of speech, which is enshrined in law. Article 9, 10 and 11 of the European Convention on Human Rights establishes the freedoms which underpin the right to protest. I also wish to point out that it would be incorrect to suggest that wrongdoing is mainstream within the pro-life community, or indeed even mainstream within protest activity by pro-life advocates. Therefore, I do categorically condemn actions by a small minority of individuals in the vicinity of these settings that are malicious and reasonably regarded to be criminal in nature. Given the threats made to staff, which resulted in 2 members being unable to be identified during evidence sessions in the Health Committee, I would like at this juncture to place on record my thoughts with those working in health care premises who are fearful and intimidated by simply going to do their job. In terms of the implementation of this bill and enforcement, I do have concerns which I feel have not been addressed. The police stipulated that it would be difficult to enforce this piece of legislation as it required continuous police presence. Now, when you look at that issue alone, and the fact that there may be policing cuts on the cards given the budget to the Justice Department and policing numbers, we must ask the question, how will this legislation be enforced without proper resources on the ground? And I did state in the Health Committee meetings that surely the Justice Minister must have some role to play in relation to this piece of legislation. Yeah.
For giving way, and she makes a very important point. Not only has the Chief Constable recently talked about the budget pressures and the effect that will have on his resources, We haven't had the numbers of police that were promised and to be delivered under NDNA. And when you talk to the police, as I do as a Belfast representative, they will tell you they're already hugely overstretched in terms of the current policing of the city centre, where there are huge problems around drugs and solvent abuse and so on.
The member is absolutely correct, and that has been raised numerous times in this House over the last number of weeks in relation to the problems that exist in policing, and it will be mostly concentrated in Belfast as well. So I thank the member for his intervention. It is likely that these provisions, if ratified, would be subject to legal challenge with implications for the taxpayer. You see, Mr Speaker, I know I've only been an MLA for a short period of time, but I am not naive, and I believe private members' bills should not be a tool to gain votes at the ballot box or simply for a line in election literature. Legislation must be there for the purpose it is intended for. It must do exactly what it says on the tin, and I do not believe this bill does deliver that as drafted. It raises expectations for staff in such facilities, the service users and the visitors who have legitimate concerns over their treatment outside the doors of premises. Persisting with unbalanced and unworkable legislation is a failure upon us as the lawmakers. My colleague Pam Cameron has set out the stall in relation to each of the clauses. However, I do again want to bring attention to some of the points. I'd like to draw your attention to Amendment 4 and 12. I believe Amendment 4 is significant and points to a U-turn on behalf of the bill sponsor. At the beginning, Ms Bailey was against the idea of including any prescribed distance on a safe access zone. Now we see distances included, and that there is no provision for the department to consider whether the distance is appropriate to the circumstances. So let's take, for instance, Belfast City Centre. What would businesses have to say about the fact that they may be included within a safe access zone? Would they be aware? Does influence come under that? Will it turn customers away from going near that area as protesters may be displaced? I know that Amendments 7 and 9 now won't be moved, as Ms Bradshaw has indicated, but I do want to give my views on them. In relation to signage, does this further add to the lack of desire from someone going into a zone and affecting businesses surrounding? Whilst I understand the intention and the motivation behind these amendments, as it removes the defence of lack of knowledge on where a zone is situated, it may also draw attention to anyone entering that zone. It is therefore has a counterproductive effect. Has the sponsor consulted with the PSNI to gauge what extent signage will actually make enforcement easier? And perhaps they could deal with that specific question in time. In terms of Amendment 6, in the name of the North Antrim member, I wish to thank him for tabling this amendment. This provision would ensure competing freedoms are balanced in the implementation of the bill, whilst taking a proactive approach to reducing legal liability for the department and potential cost to the public purse. Yeah.
I fully agree with you that none of us in this chamber want to see police time, or court time for that matter, tied up with the offences. But as political leaders, should we not be encouraging people to not protest and to have their silent prayers elsewhere, where they wouldn't be coming into conflict with the police and those people who are trying to access healthcare? Do you not think that would be the responsible position, to encourage people not to protest where it could cause those difficulties for the police?
And I ask the member, do we not have freedom of speech in this country? Do we not have the right to protest?
The member for South Belfast raises that point, because that's a salient issue that's being discussed at Belfast City Council, where people who are street preachers and evangelists in city centre, particularly Cornmarket, are being harassed by people who are opposed to their views, their religious views. And indeed, I had an old gentleman who for years has been giving out literature in St George's Market, who was refused the right to do that, and I took his case up and that was reversed. That's the sort of freedoms that this country should want to see in terms of religious freedom in this city, our capital city. It's an appalling remark from the member for South Belfast, I must say.
Remarks were in reference to the police having to intervene, take up valuable time away from dealing with other crimes. That was the point of my intervention. Thank you.
And again, I point out freedom of speech is very important. The right to protest is very important. And I think that all of us in this chamber should uphold the right to protest and freedom of speech. I would like to move on. Overall, I'm not convinced that the bill does actually deal with the matter in hand. It is not about abortion, as has been pointed out by some members in the chamber today. In fact, the issue is around some of the malicious practices that sometimes and unfortunately has operated in these areas. However,
members, excuse me, sorry, members wishing to have a chat maybe should go outside. Okay, thank you.
Freedom of speech. However, in the same token, it does not mitigate for those who wish to carry out peacefully protest, or indeed, for instance, speak to a loved one who is using an abortion service before they enter the premises, who may want them to rethink, as influence is included within this bill as an offence. Influence can be open to interpretation, and the inclusion of it is, I believe, dangerous and has ramifications for a number of groups and people. I believe the bill will displace the problem elsewhere. I believe the issues can be rectified through looking at harassment laws and strengthening them, rather than create a rush-through piece of legislation. I would therefore strongly encourage members to consider carefully this legislation, which will and may need revisited in any future mandate.
Thank you, Sir. Liz Kimmins on council call. Liz Kimmins.
And I think others will know this is a very relevant issue to my own constituency, where ironically, as we speak, there has been protesters at Daisy Hill, my local hospital, from early this morning. A weekly ritual, like in other areas, that has been causing huge distress and anxiety for many women as they access abortion services or indeed other healthcare services for the better part of 2 years now. Mr Deputy Speaker, over the last number of months particularly, this Assembly has stood united in our commitment to tackling violence and abuse against women and girls. Yet some members stand opposed to this bill, which will protect women from what is undoubtedly the targeted abuse of women. And we can't pick and choose what types of abuse we think women should be protected from. You either support the protection of women and girls or you don't. And I disagree with the view that this is censorship as well. I fully appreciate the right to freedom of speech and the right to protest, but where this is having such a significant impact on so many people, we need to put in place appropriate protections, because it is about balancing the rights of everyone. I've read the report by the Health Committee and the evidence given by the many stakeholders, which corroborates the fact that these protests have real impacts on patients, staff and members of the public, which we've been saying for months and months now. And sadly, those who are so vehemently opposed to this bill fail to address in some of their comments. For those who wish to protest, they can still do so. No one is taking that right away from them. What's being proposed here is not about creating a one-world view, as some have alluded to, nor should it create further pressures on the PSNI, as the previous member had mentioned. And I think the member for South Belfast was referencing this as well. When people know what the legislation is, they're more likely to say, right, well, I can't do that. It's like we know when there's a double yellow line there, we can't park there. So we don't need police to come out every single time we think about parking there. So I think when you put it in that sort of context, it kind of supports what the other member was referring to as well. Safe access zones are about creating safe and neutral spaces to enable women who are incredibly vulnerable to access healthcare services free from intimidation, free from harassment and free from abuse. And regardless of what the intention of those who are protesting may or may not be, the language, the imagery and the behaviour that has been used at these protests, and is well documented, that I might add, has and will continue to have a very damaging and distressing effect on women if protections aren't put in place. Women deserve better. Women who have been raped, women who have had the devastating news of a fatal condition of their unborn child, women who, for their own personal reasons, cannot continue with their pregnancy, women who are accessing healthcare or who work in these healthcare sites and who have maybe suffered pregnancy loss or are experiencing fertility issues. They all deserve better, and we have a duty to support and protect women who are going through this very difficult and often life-changing experience. So nobody should be faced with this type of behaviour when accessing healthcare. And I welcome Amendment 4 in particular, which further clarifies the distance allowed for establishing a safe zone, as this is a concern that was brought to my attention, particularly in relation to Daisy Hill, as it wasn't clear initially if the safe access zones would be in place at the front doors, would be relevant to the front doors of the building, or if indeed at the entrance and exit to the site as a whole, as that is currently where protests take place. And without this clarification, it may have been the case that the bill would have consequently had no impact in situations like or at Daisy Hill. So, Mr Deputy Speaker, of all the issues I have dealt with in my time as an elected representative, I can say wholeheartedly that this is without doubt one of the most important to many of the people in my constituency who, regardless of their views on abortion, as others have said, have expressed their dismay at these protests at our healthcare sites, particularly Daisy Hill, which is held with the highest regard by us all. And it's been widely recognised that the behaviour of many of those protesters towards women and towards staff is unacceptable. So I'm pleased this bill has now reached this stage, and as someone who is incredibly frustrated by the lack of clear responsibility for dealing with the range of issues emanating from the protests, I hope members will support it to the next stage and to its conclusion, to finally provide the Department for Health with the ability to protect its service users and staff from this trauma in future.
I now call the sponsor of the bill, Ms Clare Bailey.
Thank you, Deputy Speaker, and thank you to everyone so far as well. And I suppose it's to be expected that some members have taken the opportunity to use this debate to rehash views on abortion rather than what is actually happening on our streets, outside clinics and charities. And what is happening is the deliberate campaign of harassment and intimidation against women seeking to access services. For no other health service would this be tolerated, but because of views on abortion and reproductive health care, we turn a blind eye to this. This bill seeks to allow safe access to sexual and reproductive services. And on that one, I will quote from CEDAW, and I think that I have done this before in the past. CEDAW, who carried out a full state inquiry on the UK, something they do very, very seldom, and found in Northern Ireland that in their 2018 UK state inquiry carried out, they found that the UK's failure to protect women from harassment while accessing sexual and reproductive health services and information counted to a breach of their Article 10 and Article 12 rights under CEDAW. So therefore, women are discriminated against in accessing specific educational information to help ensure the health and well-being of families, including information and advice on family planning. And that's the context of this bill. But today, we were to be here to discuss and debate the amendments put forward to the bill, and not really in opposition to abortion. So I do find it confusing to hear that the DUP will not be supporting the bill, given that DUP councillors in Belfast City Council supported a motion brought by Green Party councillor Anya Grugan back in 2021 in June, and the DUP councillor Gareth Spratt stated, and I quote, "Our support for this motion does not affect our individual pro-life positions on this matter of conscience." Now, while acknowledging liberty of speech and the right to protest, he also stated how, and I quote, "We must ensure protection of already vulnerable women and the prevention of trauma." And DUP councillors in Newry, Mourne and Down Council also supported a motion calling for exclusion zones like those proposed here. Yep.
Got stuck there. I thank the member for giving way. My problem is with how this piece of legislation has been drafted, and I outlined in this chamber today my concerns in relation to how enforceable it will be on the ground and how it will work in practice. That is what I have stated in the chamber today. So my concerns are centred around how this bill is actually drafted and how this legislation will actually have outworkings on the ground.
Member for her clarity on that one. During the consideration stage, you've opposed the bill today, saying that you cannot understand the rationale of some amendments before us. Deputy Speaker, I think it's fair enough to say that there would be no amendments to this bill that would be accepted, as they just don't want to see the bill pass, exactly like Mr Allister, and he's very upfront about that. And addressing concerns around automatic setting of zones and the publication of such that have been raised, I think it is unfortunate that the Minister is unable to attend today, but I do want to make members aware that both I and the committee have been given every assurance from the Minister that he will address this. And if it's okay, I'll let you know that the Minister has stated that his department will develop a policy statement if this bill is passed, setting out how it intends to implement the requirements around safe access zones, including guidance to operators of HSC premises and display of clear and appropriate signage at protected sites. So again, I hope that will go some way to giving reassurance to those who shared any of those concerns. And the Health Committee's call for evidence on this bill closed, as we heard, back on the 12th of November 2021. And it was a call of evidence that led to the submission of 45 written responses from organisations and 6,412 submissions from individuals. And I do note the high number of responses to the call for evidence, and I'm pleased with the level of engagement, particularly from those impacted sectoral bodies, as it will undoubtedly help me and us, if possible, improve the quality and robustness of this final piece of legislation. And while I note the volume of responses from those opposed to the bill, these responses tend to rely solely on the rights of those engaging in activities outside sexual and reproductive healthcare clinics, such as freedom of assembly, freedom of speech, etc. But these are not absolute rights. However, and it's not sufficient to say that because this bill will restrict these rights in certain circumstances, that it is therefore not compliant with human rights. The reality is much more nuanced than that just simple binary understanding, whether that be deliberate or not. It requires a balancing of rights. And indeed, as the Northern Ireland Human Rights Commission highlighted in their evidence session, the court in the Ealing case found that had the local authority not taken action to ensure access to the clinic, they would have been breaching the human rights of those
members,
patients.
there's a conversation going on which is audible up here, so if members wish to have a conversation, please do so outside. Thank you. Please continue, Ms. Bailey.
Thank you, Deputy Speaker. Certainly.
I've listened with interest on a number of occasions about the references to Articles, I think, is it 9, 10 and 11. But as you have stated, and just expand on that, in each one of those freedoms, in each one of those articles, it also clearly states that if in the exercise of them, an individual is breaking public order or is impacting other rights or is impacting public safety, then consideration can be given to providing a way of restricting those rights. It's quite clear in there that if somebody breaks those rights, that they can be held account for that. Would you agree that that means that what's contained within this bill actually is compliant with those articles?
Thank the member for that, and he's absolutely right. There are caveats within those rights, but those caveats need to be prescribed by law, which currently they're not, which is exactly what this bill seeks to do. So rather than wipe out protest, as some think it's seeking to do, it doesn't. It simply prescribes in law, under human rights articles, the balance of those competing rights. But going back to the Ealing case that was taken, where it was found that had the local authority not provided zones, that it would have been the authority that would have been in breach of the human rights to those patients needing access to abortion services and information. And given the findings of the CEDAW UK state report that I've already referenced, the overwhelming evidence provided by the Trust to the committee and the testimony of service users and staff included within many of the responses to the call for evidence, it's clear that there is an urgent need for intervention like that proposed in this bill in Northern Ireland at this time, in order to ensure that safe access to legally available services and information is permitted. And I have listened intently to the Health Committee's evidence sessions over the last few months, where they have heard oral evidence from the Northern Ireland Human Rights Commission, the Health and Social Care Trusts, the Department of Health, the Police Service of Northern Ireland. I've been happy to engage with the committee, the Department, the PSNI, the Human Rights Commission, the Attorney General, the Office of Legislative Counsel as well, in order to help inform my decisions around what amendments are needed to give effect to my intention around this piece of legislation and ensure that it is workable and effective if passed. The Northern Ireland Human Rights Commission, the Trusts, the Department of Health all made it clear in their oral evidence sessions that there was no alternative legislation or regulation already in place that could deal with the problem. Harassment laws required a course of conduct to occur before action can be taken. There are two issues with this in the context of what is happening outside sexual and reproductive healthcare centres. First of all, a patient attending a sexual and reproductive healthcare centre for the purposes of accessing abortion services in all likelihood will only attend that centre once. And this debate had been had during consideration stage as well, but I feel the need to repeat it since it was brought up again. So the offending behaviour is unlikely to ever be considered a course of conduct, as it will only happen on one occasion. Certainly.
Harassment, of course, is only one issue. There is the public order, which makes it an offence to use written material that is threatening, abusive or insulting. Under the same order, disorderly behaviour is a criminal offence, and there are also other provisions to condition public gatherings. So it's not just about harassment. There are multiple opportunities to deal with untoward and unsuitable behaviour.
Thank the member for that, and they're all deemed insufficient and inoperable under these circumstances, which is exactly why the behaviours and the distress is happening, which is exactly why the committee were told by Health and Social Care Trusts that they have now put, I think, was it strengthened windows in some of their premises, that they've had to move services to other places, that staff have had to change their journeys from work, that women coming in presenting with miscarriage were nearly not coming into the centre to seek those access to services, where if they didn't, their life would have been at risk. So the current legislative framework does not work in these circumstances, because the harm must have occurred as well for action to be taken. And we heard very clearly, I think, from Claire Sugden during the last debate at second stage, that this bill seeks to be a preventative bill rather than seeking to address harm when harm has been done. And I think that this is critical in the circumstances that we're talking about, to ensure that the rights of someone accessing services are protected. And as the Human Rights Commission stated in their evidence session, it is too late to seek redress once access to healthcare has been impeded. Again, backing up what was brought up during second stage debate. So therefore, it is important that legislation is capable of preventing harm from occurring in the first instance. And before going on to discuss the amendments individually, I would like to reiterate my condemnation at the threats that have been levelled at the officials in the department for merely doing their job and for working on this private member's bill. This is completely out of order, and I want those officials to know that they have my full support. I hope that this unfortunate incident might concentrate minds in this chamber to how serious
Excuse me,
the
Ms
issue
Bailey.
at hand is.
Members, if you wish to conduct conversations, I re-emphasise that outside is the place. Please. I beg your pardon, Mr Clark. Sorry, you weren't. You were standing having a conversation. Okay. Ms Bailey, please continue.
Thank you, Deputy Speaker. Those engaging in the behaviour that we're trying to regulate are causing real harm and are traumatising women and pregnant people, staff and wider public. The behaviour is not low level. They are not there to help or support. They are there to bully, harass and intimidate someone from accessing healthcare safely and in confidence. The fact someone felt so threatened by this legislation that they deemed it acceptable to make a threat against officials goes a long way in highlighting the mindset of some of the people involved. Now I want to address the clauses specifically. So Clause 1, and on the advice of the OLC, I'm now proposing that Clause 1 no longer stand part of the bill. This clause provided an overview of the intention of the bill. However, it added no substantive legislative content and may be confusing while read with the provisions elsewhere in the bill, so it was deemed not necessary to include it, and I was happy to take that advice on board. The Amendment 1, I'm proposing this amendment just to tidy up Clause 2 of the bill, and I'm amending this to refer directly to the Abortion Northern Ireland No. 2 Regulations 2020. And this is important to ensure consistency with the language used in other legislation, and so that the provisions of this bill will relate directly to the commissioning of abortion services going forward. This amendment also ensures that the bill's remit is contained to only those premises where it is required, as a premise will only become a protected premise when notice is given to the Department of Health by an operator that it wishes to become one, rather than applying a blanket zone to all premises capable of becoming protected premises. While I know the will of the Department and the Committee and the number of key stakeholders was that the safe access zone would automatically apply rather than through some sort of process with the Department of Health, I believe that this amendment allows a zone to be established by way of this legislation without such a process being necessary, but in a way that makes it workable in practice. Members will note that on the Marshall list states satisfy conditions 2 and 3, but then goes on to outline condition 1 and 2. This is a processing error, and apologies. I've spoken with the Bills Office in relation to this, and it will be corrected in the printing of the bill following this stage, should the amendments pass. Amendment 3, Clause 3, sets out how certain premises that provide information, advice or counselling about abortion can also become protected premises. This amendment takes out the requirement for the Department of Health to make a determination that such a premise can be treated as protected premises, and instead replaces it with a provision that such premises can become protected premises by virtue of fulfilling the 3 conditions set out in this clause. The advice that I've received from the OLC is that this is preferable, as the conditions set out in the legislation are sufficient without the need for additional steps of the Department needing to make a determination and any additional issues created by that process. This is also commonplace in other bills where safe access zones are operable in other jurisdictions. Turning to Clause 5 in Amendment 4, a considerable number of submissions detailed the preference that a minimum distance for the extent of the zone to be detailed within the legislation. The Department of Health in particular had raised concerns with me over the difficulty in the original drafted provisions within the bill that would present for them. I recognise that including a minimum distance would simplify the process of designating a zone somewhat. However, I'm also mindful of the evidence provided by the Human Rights Commission that previous jurisprudence on this issue is clear, that it is not the general principles of a zone that a court would determine on, but on the specifics of that zone. And for that reason, I'm proposing that Clause 5, as originally drafted, does not stand part of the bill, and instead proposing a new Clause 5A in Amendment 4. In order to ensure that any zone established under this legislation is effective, but only as big as is necessary to meet the aim of the bill, this amendment would set a distance of 100 metres from each entrance and exit point of a protected premises, but with the option to extend this to a maximum of 250 at the request of an operator, should it be required due to the specific geographical setting of a particular premise in order to meet the objectives of the bill, which is to ensure safe access for protected persons as laid out in section 4 of the bill. And again, trying to address some issues that was raised about private operators. I think it was Mr Allister had raised that. I don't see anywhere in the Northern Ireland abortion order where private operators will be part of this bill. So I hope that lays rest of those concerns. The premises are stipulated under the Northern Ireland Abortion Order, the Regulations 2020, and they are the premises that will be in the context of this bill as well. Looking at clause 6, there's an important balance to be struck in section 6(2) of the bill, so that the identification of what constitutes an offence is flexible and inclusive enough to encompass the full range of behaviours that have the capability of causing harm to a protected person inside a safe access zone, while also giving enough certainty and clarity to those trying to enforce the law. And as the Northern Ireland Human Rights Commission spoke to at their evidence session, I don't think it is helpful to be too prescriptive in the legislation, as this could lead to a situation where we see attempts to go by the technical letter of the law and not to comply with the spirit of the provisions contained within the bill. As I've seen personally, and as the Health Committee heard throughout their evidence sessions on this bill, the type of conduct that can have the effect of impeding access to a sexual and reproductive healthcare centre is incredibly varied, and taken out of context may not always seem too problematic. But when it is targeted on an individual trying to access services, it absolutely can cause harm and distress, and ultimately impact on their right to access healthcare safely and in confidence. The health trusts were also clear about the cynical tactics employed by those engaging in this type of activity outside their clinics, where one person would harass a woman on her way into a clinic, another would harass her on the way out, in order to evade any potential consequences under the existing harassment laws, as has been mentioned. And as such, I'm content that the wording of section 6(2) as it stands is sufficient to cover the full range of offending conduct, as it focuses on the intention and the potential effect of the behaviour, rather than detailing specific types of behaviour that could be worked around by those intent on intimidating women. There has been some concern raised in the written submissions that the level of fines for an offence may not be severe enough to act as a sufficient deterrent. And the primary aim of this bill is not to criminalise individuals, but to ensure safe access to services. And in my view, the creation of an offence, as well as powers given to the police under section 7, requires an individual to leave the zone, and associated offence for non-compliance will be sufficient to ensure the effectiveness of the zone. As such, I believe clause 6 is appropriate as a whole, and I am firm in my support that it stands part of the bill, but with a slight amendment. Amendment 5 removes subsection 4 of clause 6, and this was to take account of concerns raised by the PSNI around the difficulty this would pose for them in terms of trying to enforce the legislation. And I understand that in practice this would have little effect in terms of protections for anyone charged under legislation, as they would still be free to rely on any defence, so any defence they wish, should they be facing any court proceedings, without the explicit reference to that in this bill. Clause 8 and Amendment 8. I'm proposing that Clause 8, as originally drafted, doesn't stand part of the bill, but rather Amendment 8 will create a new Clause A. Most of what was detailed in Clause 8 is no longer required due to the more limited role for the Department of Health in establishing the zones in Clause 5A. The new Clause 8A sets out more clearly what role the Department of Health do have in publishing protected premises and safe access zones, And I know the issue of publication and making sure that people are made properly aware of a safe access zone was something that came up repeatedly during the committee's evidence sessions, during the debate today as well. And I hope that this new clause 8A will go some way to addressing that issue and those that were raised. It puts a clear obligation on the department, but importantly, it is not too prescriptive within the legislation and gives them flexibility to publish the zones in the manner that they deem appropriate. I'm cognizant of the fact that not every zone will be the same, and as such, how they're publicised may not also need to be the same. So this proposed amendment gives the department the space to come forward with their own policy on how best to meet those obligations within Clause 8A. And I believe that that's their preferred option, as I've already stated. Clause 9. A number of written submissions again expressed concern about Clause 9 of the bill, as they felt that some of the listed rights were in direct conflict with the rights of those accessing the services. And while this may be the case, any safe access zone established must be proportionate and reasonable restriction on human rights. Therefore, it's sensible that all engaged rights are considered when a zone is being established to ensure this balance is struck. And I am concerned that the Department of Health, however, has stated that it would not be an appropriate function of the department to carry out this assessment and that they would not have the competency to do so. And as the Human Rights Commission has pointed out in their written evidence, Section 6 of the Human Rights Act 1998 requires that public authorities do not act in a way that is incompatible with the ECHR. As such, the requirement to ensure that the actions of the department are compliant with human rights should be well established under current practice and how they operate at all levels, and should not be a particularly onerous requirement. While they are not the ultimate arbitrator on human rights issues, that does not preclude them or indeed lessen the responsibility to ensure that their actions are compatible with human rights under the 1998 Act, and is something that actually would be required, whether or not it was expressly stated within this bill. And indeed, the Northern Ireland Human Rights Commission expressly recommended this in the response that the department carry out a human rights impact assessment on a case-by-case basis when designating a zone. But that being said, I'm now proposing to remove this section from the bill, as the amendments tabled today mean that the role of the department in establishing a zone has been greatly reduced, and as such the section is no longer required, given that the department do not have as many functions to exercise as was originally envisaged. The clear will of the department, the committee and the number of stakeholder key organisations that responded to the call for evidence was that the bill itself establishes a zone, and this is the one of the amendments required to tidy up the bill, given the changes that have been proposed to take this into account. Apologies, Speaker, I had a tooth removed yesterday and I'm feeling myself getting a bit stuttery, but I'm nearly done. Amendment 10. This, as a result of the proposal that Clause 9 does not stand part of the bill, a change is then also required in Clause 11 to remove mention to the Convention, as it no longer is required. Amendment 11. There has been some confusion in the written responses as to the meaning of Section 6.3 and to what extent this provision covers the recording of a protected person who is in a safe zone. The intention of this provision is that any recording, whether that be video, audio, photographic, taken of a protected person, while that protected person, thank you so much, excuse me. Thank you, Paula. The intention of this provision is that any recording, whether that be video, audio or photographic, taken of a protected person while that protected person is in a safe access zone, irrespective of the location of the person doing the recording, could be classified as an offence under the legislation. And it came through quite clearly during the committee stage of the bill that the committee wanted to make sure that this clause was capable of covering the full range of behaviours related to recording of protected persons. So I'm proposing to provide a definition of recording in the interpretation clause of the bill at Section 11 in order to ensure that this is the case. Finally, on Amendment 12, again following the advice of the OLC, Amendment 12 seeks to provide the definition of what is meant by premises in this bill. It is necessitated, as it is envisaged, that the type of premises that could potentially require protection under the bill are quite varied, and it is important to ensure that safe access zone is effective regardless if the premise is a large hospital site or a floor of a shared building. So it is helpful to provide a clear direction in the bill what is meant by the term premises. This amendment also clarifies what is meant by attending a premises for the avoidance of any confusion in relation to the determination of a protected person. Speaker, all this bill seeks to do is to provide for safe access to abortion services in Northern Ireland that women currently do not have. And by moving people seeking to impede access 100 metres away from the entrances to and exits from premises does nothing to shut down any anti-abortion debate or activism. I hope that all members can understand the difference and that they can stand by women and staff rather than, as was alluded to earlier by Ms Erskine, rather than eyeing up votes. This is not about votes. This is about protection and safety measures that currently do not exist for access to free, safe, legal services in Northern Ireland. Thank you.
I thank the member, and I call Jim Allister to wind.
Thank you, Mr. Speaker. In briefly winding up this debate, I want to begin by refuting absolutely the undercurrent of suggestion that to oppose this bill is to embrace or to endorse abuse or attacks. One member even used the word violence against women. To oppose this bill is to say very clearly to this House, the existing law is such that violence against women, abuse of women, is provided for in already stipulated legislation, and that this bill is a huge assault upon fundamental rights, namely the right of expression, to the very point where the sponsor of this bill is removing the least reference to protection of human rights, which was in the original Clause 9. So absolutely, I am not standing here, nor do I tolerate the suggestion for one moment that in opposing this bill I am endorsing in any way any of the things that have been described or ascribed to opponents of this bill. It was noticeable to me that the very significant step of introducing self-certification of exclusion zones and removing the role and the oversight and the scrutiny of that from the department, and to self-certify, to create a situation where the operators could self-certify these zones and self-certify their extension, that was attempted to be written off by the sponsor of the bill as tidying up. It's nothing like tidying up. It is a fundamental departure to say in legislation that areas from which members of the public can be excluded. It can be something decided on the whim of the operator within 150 metres, rather than, as it was in the original drafting of the bill, by the department. That is a mammoth step that has been taken in these amendments and is anything but a tidying up. I also noted in this, in the contributions of those who are avid supporters of this bill, no one tackled the issue of why it's necessary to include in Clause 6 the wide ambit of criminalising influence. It's easy to talk about criminalising harassment and abuse and violence, of course, and they already are criminalised. But what this bill does in Clause 6 is to criminalise an influencer, anyone who stands in silent protest, saying nothing, absolutely saying nothing, is nonetheless criminalised if they are an influencer. Now, nobody who supports this bill has risen to their feet in this debate to justify that. And that's because it's unjustifiable. It is a step far too far in any legislation to say that if you try to influence someone in the public sphere, you are a criminal. Yes?
The member makes a very important point because you know, we hear in relation to anybody who, and there is an undercurrent that anybody who is within a pro-life organisation or holds that view, that they are all antagonistic and that they are all shouting and hurling abuse outside certain premises. And we know that that is not always the case. So he makes a very important point in relation to that important aspect of this bill.
And if there are people shouting abuse and being violent and doing all the things that have been suggested, then arrest them. Arrest them for disorderly behaviour. Arrest them under the public order. Arrest them for various offences which already exist. But do not paint everyone who out of conscience has a protest to make and does it legitimately and does it respectably. Do not paint them as criminals. And that is what this bill does. And that is the primary offence of this bill to those who take a contrary view to the promoters of this bill about abortion. It is scandalous that this bill seeks to criminalise someone who legitimately holds a point of view but can never express it within a sanitised area. And all they are seeking to do is influence, not to be violent, not to be abusive, just to influence and to to stand for what they stand for. And yet, this bill is going to criminalise it. That is appalling. Yes?
Thank the member for giving way. I have direct experience of what's happening outside the doors of these centres. And when we're talking, and I think that I addressed it when I was addressing Clause 6, and how being too prescriptive then doesn't allow for taking into account what's happening on the streets. I mean, during my time working with the Mary Stopes Clinic, what was happening at the doors was not protest, Mr Allister. It was not protest. It was a deliberate campaign of harassment and intimidation to stop me doing my job and to stop women seeking access to that building, regardless of whether they were going to the 8th floor, the 9th floor, the 4th floor. I have been spat on, I have been physically assaulted, I have been splashed with holy water, I have reported to police, I have had it all caught on GoPros, I have caught it on CCTV cameras, and again, the police cannot deal with it under existing legislation because they say that it is insufficient, or else they can't gather enough evidence in order to secure a prosecution. So existing legislation is simply not enough. What is happening when the word influencing is put in there is there deliberately to capture the whole raft of behaviours and how that twists and turns in order to allow this deliberate campaign of harassment to continue. And that's what it seeks to do.
If the member was spat on, that was an assault. If the member was abused, that was a breach of Article 9 of the Public Order. If she was threatened, likewise, and subjected to threatening, insulting and abusive behaviour, those are offences. Also, the people doing that would be guilty of the offence of disorderly behaviour, and if it was a course of conduct, it would have been harassment. Now, there's a multiplicity of things in the criminal calendar which deal with that situation, but what the member wants to do is to push out the limits so that the person who does none of those things, who simply stands there, maybe with, as I quoted this morning, maybe with a quotation from the 6th commandment, thou shalt not kill, that person becomes a criminal because they are an influencer. They haven't spat on anyone, they haven't shouted at anyone, they haven't opened their mouth, they haven't been abusive, they've stood there. Now, that person under this bill becomes a criminal, and that's where this bill goes far too far. And as if that wasn't bad enough, then within this bill, it makes the offending absolute offences. Because one of the amendments is to take out Clause 164, which did provide a defence that if you didn't know or no reasonable way of knowing that the protected person was in a safe zone, then you hadn't committed an offence. Now, well, when I finish the point. So what the member is saying to this House, that she wants to create an absolute offence. Now, absolute offences are few and far between, and they're there for public policy reasons. One of them is it's an absolute offence to drive your car without insurance. Why? Because there's compulsion to compel people to have their car insured. Therefore, it doesn't matter. You can say, I forgot, my wife forgot, whatever. There's no defence. You are going to put into that category of absolute offence this business of criminalising somebody who's an influencer. Now, if that's not a step beyond what's rational and reasonable, I've no idea what is. Yes.
I think the member, you're much more well versed in legal and courtroom procedures than I, but a reasonable defence can be employed by anybody for any context, for any charges, in any courtroom, at any time. Is that right? It does not need to be stipulated in primary legislation that you can use reasonable defence as a defence.
If the member is finished, I don't recognise the phraseology of reasonable defence. Unless something specified in the relevant legislation, then either the offence was committed or not. Some legislation, and this is maybe what the member is thinking of, says someone without reasonable excuse. But your legislation doesn't say that. It doesn't say that someone commits an offence if without reasonable excuse. If it was there, that would be a different matter. But the member has created an offence which is an absolute offence. There is no reasonable excuse to being an influencer. You're a criminal. Absolute. So you know, the member need not rise to say, oh, you can always rely on reasonable excuse. You cannot, unless it's in the legislation. There's no legal defence of reasonable excuse. And the member should know that. And certainly, if she was considering that, would have known that. So we're in a situation where absolute offence has been created for somebody who's a mere influencer. And the question to this House is, how could that be conscionable? Yes?
The member for giving way, and just to go back to that point around how someone can stand and hold, as you say, a placard with scripture, and I go back to my original point. I get that it may not be seen under current legislation, and that's why we're here today. We wouldn't be having this debate if that was the case. But a person holding up a placard that claims that a woman going into that facility is a murderer, or a member of staff going into that facility is killing babies, how can that be deemed as acceptable? I mean, it's about the impact of that on all of those people, and that is why we're here today. So it's about making it. We're not taking that right away. We're asking people to move to somewhere else where you're not creating that much. It's harmful. It's plain and simple. It's harmful to the people impacted.
The member is saying that it is offensive, abusive, harmful to quote Holy Scripture, in particular, one of the 10 Commandments. And to simply say, thou shalt not kill, then that's an appalling position, I'd suggest, to be in. To say that you cannot bear witness to the fact that it is wrong to kill. Now, if you can't say thou shalt not kill, then the corollary of that is to say, well, you shouldn't offend anyone by telling them they shouldn't kill, and indeed carry on killing. That's, you know, if the offence said thou shalt, if the placard said thou shalt kill, would that have been offensive? But once it says thou shalt not kill, suddenly as an influencer you're a criminal. That's where this legislation is taking us, and that cannot be right. Yeah.
I actually didn't even mention Scripture as being the offensive part. I said that the offensive part is when people are blatantly called murderers, because that is the language that is used. Babies are killed in here. That is the language that is used. I fully respect people's right to freedom of speech around their religious views. But the reality is, as well, that not everybody using those facilities share the same religious views. So that's another debate for another day. But I think that's very important, that we can't be using the view of one religious sect to influence others. So that's the point I'm making. It's the impact on people that we're talking about here.
Well, the member's making a different point. Because when she first intervened, she talked about if you hold up something that says something offensive. If the member is talking about abuse being hurled and someone being called a murderer, if that is something which is threatening, abusive or insulting, it's already a criminal offence. I'm talking about the individual who does none of that, but who stands outside to demonstrate their opposition to abortion. I'm saying, why are you criminalising that influencer? Why do you think it's necessary to go beyond those who are abusing and threatening and insulting to incorporate those who are influencers? That's what this bill is doing. And that's the point that no one in this debate addressed whatsoever. And as I was making the point, is now even more compounded by the fact that it's now an absolute offence. So this is the most draconian of legislation. And though this House will, I say to it that it shouldn't approve this legislation.
Okay, members. So before I put the question, I do remind members that we have debated the opposition to Clause 1 stand part, tabled by Mr Allister and Ms Bailey, but the question will be put in the positive as usual. The question is the Clause 1 stand part of the bill. All those in favour say aye. Contrary, no. The noes have it. The noes have it. The noes have it. Amendment 1. Amendment 1 has already been debated, and I call Ms Clare Bailey to move formally Amendment 1. Moved. Amendment proposed to Clause 2, page 1, line 8, leave out and insert words as printed on the marshal list. The question is that Amendment 1 be made. All those in favour say aye. Aye. Contrary, no. No. All those. Clear lobbies. The House will divide in 3 minutes. The question will be put in 3 minutes. Okay, members. Order, members. Resume your seats, please. Okay, members. Stuart Dixon, Paula Bradshaw are still members. Stuart Dixon. Mr. Dixon, you're still a member. Applies to you. Thank you very much. Thank you. Okay, members. The question is that Amendment 1 be agreed. All those in favour say aye. Aye. Contrary, no. No. Do we have the tellers? Okay, members. Tellers have been appointed as follows. Tellers for the ayes are Paula Bradshaw and Claire Sugden. Tellers for noes, Jim Allister and Deborah Erskine. Remain all members of the requirement of social distancing while the division takes place. Clear the lobbies. The Assembly will divide ayes to my right and noes to my left. Secure doors. Thank you.